Good morning, everyone. Welcome to our webinar, Contract Cheating in Canada, Exploring Legislative Options. I'm Sarah Eden, and joining you today in my capacity as the Educational Leader in Residence for Academic Integrity through the Taylor Institute of Teaching and Learning. And I'll turn things over to my co-presenter so you can introduce yourself.
Good morning, everyone. Thanks for joining us this morning. We're really excited to speak to you about this topic. My name's Alicia Adlington. I am a JD candidate, so I'm in my second year of law school at the University of Calgary. And again, welcome. Happy to have you here this morning.
We wanted to start by acknowledging that we're joining you today from the traditional territories of the people of the Treaty 7 region in southern Alberta, which includes the Blackfoot Confederacy, comprising the Siksika, Piikani, and Kainai First Nations, as well as the Tsuut'ina First Nation and the Stoney Nakoda, which includes the Chiniki, Bearspaw, and Wesley First Nations, and take a moment as well to recognize that our home, the City of Calgary, is also home to the Métis Nation of Alberta, Region 3. In the time that we have together today, we hope to provide an overview of academic integrity and contract cheating briefly. I'm assuming that if you're joining us today, you're already familiar with some of the basic principles, so we won't spend as much time on that as we will on the remainder of the topics around legal structures in Canada and existing worldwide contract cheating laws, the role of quality assurance bodies, and future directions for Canada, concluding with some possible recommendations. And just to make a note as well, to remind everybody that this session is being recorded. Participant names will not be recorded, and neither will the chat. We do have a webinar production coordinator working with us in the background today. Her name is Helen Pethrick. She'll be moderating the chat for us throughout the session. Please feel free to ask your questions and make comments through the whole session. Helen will record them or note them down and then ask us the questions at the end. So we can move on to the next slide. No doubt many of you are already familiar that there are a variety of definitions for contract cheating. We chose this one because two of the individuals who wrote it have a legal background, and that contract cheating occurs when a third party makes a contribution to the work of the student such that there is reasonable doubt as to whose work the assessment represents. This definition guided today's webinar and also the accompanying report that we have just finished that we're going to share with you by the end of the session today.
Okay, so to begin, what we're going to do is provide you with just a brief overview of where we're coming from with respect to our legal structures in Canada. So this will become pertinent as we get into some of the later slides and content towards the end of the presentation. So briefly and succinctly, the way the law works in Canada here is we essentially have two branches. So we have our branch of public law. So this consists of constitutional, criminal, and administrative law. So this is typically action that we see between the government and peoples. So this is where you see your charter litigation, if there's a judicial review of a decision that's been made by a government or a government body, things like that. And then of course, criminal law, which we will also get into in detail as we go through our presentation. And on the other side, we have private or civil law. So this predominantly consists of contracts, torts, and property. So this is where you have a plaintiff and a defendant, and these are two private individuals. Sometimes we have a company as well in the mix. So this is where you have the essentially party versus party, the private parties together, obviously having a dispute because we do have an adversarial system here in Canada. I also wanted to touch on our constitutional division of powers. Again, we'll come back to this as we go through the legislation, especially legislation in other countries, and why we've seen legislation enacted in other Commonwealth countries, but not here in Canada quite yet. So our supreme law here, of course, is the Constitution Act. And I wanted to point out some important provisions within the Constitution Act that impacts some of the work that Sarah and I have been doing and some of the things that we've been looking at with respect to contract cheating laws. So Section 91, this is the legislative authority of Parliament of Canada. So this essentially talks about what the federal government has jurisdiction over from a legal standpoint. So this does include criminal law. And then Section 92 talks about exclusive powers of provincial legislatures. So this is the power that provinces and territories have within Canada and what they have jurisdiction over. So this includes property and civil rights in the province. And property and civil rights has been essentially more broadly construed to include commerce and trade within a province. So this question does come up, when we think about companies and operations and that sort of thing, why this potentially wouldn't be something that's addressed by the federal government. The reason is that the federal government essentially looks after trade and commerce from the standpoint of Canada as a country, so working with international bodies and that sort of thing. Whereas within the province itself, that is under the jurisdiction of the province. So that's where you see property and civil rights encompassing trade and commerce within a province itself. And then we have Section 93, which talks about education. And education is considered to be a provincially run body, essentially. So higher education, K-12 education, things like that. So when we started exploring the idea of contract cheating and the law, what we wanted to do is think about the ways that contract cheating issues and the law interact with each other. And a couple of the ideas that we had were looking at civil action. So what kind of action is available if we're looking at this from that civil or private law standpoint? And then we also looked at this from the public law standpoint, and we wanted to explore criminal charges. So criminal charges against contract cheating companies, is that a possibility? In our opinion, neither provide a good solution at this point in time. And I should say as well that the content of the webinar we're providing today is more informational. This shouldn't be taken as legal advice. This is just we're sharing our thoughts and speculative research that we've done on this. So just that caveat there. And what we ultimately want to suggest is that the enactment of provincial regulatory offenses that sanction contract cheating activities is the way to go. And we're going to go into this in a little bit, but what we wanted to do is begin by exploring the existing laws in Canada. We are focusing on Alberta. That's where Sarah and I are situated at the moment, and talk about why this is our recommendation. So the first thing we wanted to look at is what's the legislation in Alberta? So as noted, Section 93, this is a provincial matter. So each province and territory in Canada will have similar legislation. So here in Alberta, we have the Post-Secondary Learning Act. And what this act does is essentially grants post-secondary institutions with the authority to manage their affairs. And I've highlighted some of the provisions within the act. I won't go into them in too much detail today, but as you can see, post-secondary institutions can determine, programs of study, authorize the granting of degrees, and they also are authorized to discipline students. You see this and we looked specifically at the University of Calgary. So we have our student academic misconduct policy, and this policy essentially addresses academic misconduct coming from a student, and provisions within the policy itself do talk about plagiarism, and contract cheating is included under that definition of plagiarism. So this has been identified as something that students can be disciplined for if they engage in this. So if they're purchasing work and they are submitting it as their own original work, this is a violation of the student academic misconduct policy. We also took a look at some of the case law that exists, and I wanted to highlight this. It doesn't specifically deal with contract cheating in the traditional sense, but it does involve plagiarism. So this was an individual, it was found that he had plagiarized a portion of his master's degree, and the university chose to rescind his degree, the master's degree that was awarded based on the fact that part of it was plagiarized. So this was brought to the court for judicial review, just to see if the decision was one that could stand. And we wanted to highlight this note from the sitting justice that said that denying the university the power to revoke a degree based on a subsequent finding of academic dishonesty would sterilize its ability to bestow meaningful academic credentials and maintain institutional integrity. So we really wanted to point that out because I really think that this speaks to why we're all here today and why we engage in work that's related to academic integrity. At the end of the day, this is about bestowing those meaningful academic credentials, so ensuring students have rightfully earned them and maintaining that institutional integrity. So I think over to you, Sarah, for this one.
And Alicia has mentioned how there's a mandate that's part of common law and legislation for post-secondary institutions to protect their integrity. And in addition to what we've presented on the slide, I can tell you orally that there was a review conducted as part of another graduate student's thesis. It's 2016, a fellow by the name of Ned Kelleher conducted a review of 141 cases of student conduct that had made it to the courts, and by and large found that courts in Canada will uphold the decisions of universities related to academic misconduct, providing there's been no breaches of procedural fairness. So this further reinforces what Alicia was talking about. The Meeser case that she highlighted in her slide came out after Kelleher had conducted his analysis in his doctoral thesis, but it further serves to confirm that basically the courts don't interfere with decisions made at colleges and universities regarding misconduct unless there's been some egregious breach of procedural fairness. And we wanted to also talk about the contract cheating will undermine our post-secondary mandates, and can just speak briefly and orally to some policy analysis that we've conducted in Canada of academic misconduct policies. We've been looking at universities and colleges across Canada. By and large, contract cheating is addressed in academic misconduct policies in indirect and vague terms. There are some exceptions. Particular universities and colleges will actually name contract cheating, but by and large, we use vague language such as unauthorized assistance or third parties. Right now, we currently have no mechanisms in Canada for contract cheating companies to be sanctioned. I know that there are local level initiatives underway at universities and colleges to have materials removed from commercial file sharing sites, etc. But largely, we have very little compared with other countries. So the question we asked ourselves in completing this report was, how do we fight back against contract cheating in terms of what we have at our disposal? We turned to the existing literature and in particular looked at work done by Draper and Newton and Lang and others. We can move on to the next slide. And some of the scholarship that had been provided by legal experts around contract cheating. And they've looked at various legal options, what would work, spoke to issues of territoriality and other complexities around this that make it difficult to prosecute. For example, when the student, the company, the website that hosts the company, and the individual supplier who completes the work on behalf of the student might all be in different jurisdictions. So they pointed to a number of complexities that might make it difficult to prosecute. And also, Alicia, I wanted to hand it over to you to speak to the second bullet point here about the student's ability to sue the contract cheating supplier.
Yeah, thank you, Sarah. So as Sarah noted, like the paper and the work that was done by Draper and Newton, so they suggest that we have a contractual relationship, which would be governed by contract law. So what this means essentially is that if we were to address contract cheating from the standpoint that the student and the company have engaged in that contractual relationship, we can because of a concept called privity of contract. So that means that those who are involved in the contract can essentially take action against each other if there is an issue. And again, we point to the fact that this is a matter of civil law with a plaintiff and a defendant. However, we do want to point out a few issues with this that go with our suggestion that civil law is perhaps not the way to address this growing issue that we're seeing with contract cheating companies essentially taking advantage of students. So we wanted to present a hypothetical example. So let's say we have a student and they have purchased some work. So they might decide to argue that they were induced into purchasing the third-party materials from the contract cheating company. And the quote here is the kind of language that is used by these companies. So this comes from an Australian decision, which we'll actually discuss later in this presentation. But this is what the website essentially said. You know, it's promising, you know, no plagiarism policy. You're not going to get caught. This is a way for you to enhance your grade. So you can see why students would be induced into purchasing this material. And maybe we have a student who feels that they didn't get what they paid for, or something along those lines. Maybe they're caught and they are charged with plagiarism under a student academic misconduct policy. So then what happens? The student decides, you know, this is really unfair, and I won't get into the the moral aspects of that at this moment. But if we are looking at that contractual relationship between the student and the contract cheating company, there are a few things that we thought could potentially be brought forward. So the first is fraudulent misrepresentation. So this occurs, it's a concept in contract law that occurs when a company has made a false representation and the person who engaged in the contract feels that this representation induced them into entering into the contract. So that's kind of what we have here. So I'm going to go back to this slide where maybe the student feels that they've been induced into purchasing these materials. But this is difficult to argue because you need to show that there was that intent element associated with the fraud, so that the contract cheating company intended on inducing the student into entering the contract through their fraudulent misrepresentation. So as you can imagine, this can be difficult to litigate because there is that mental element associated with fraudulent misrepresentation. Another thing we thought might be possible, so there's another concept, the unconscionable agreement. So this is where we have unequal bargaining power, and this creates an unfair contract. So this is where someone, it's usually the person who is creating the contract, so someone that is offering some kind of service and that kind of thing. So they are, they have much more power than the other side who enters into the contract. So here, obviously, we would say the contract cheating company has much more power versus the student. And this is also difficult to litigate because this has to result in something that the courts call an improvident bargain. So essentially what that means is that the unequal positions that the parties were in just created a completely unfair bargain at the end of the day. But again, this is difficult to litigate. And these are some of the issues that we thought would arise if students were to, take action against a contract cheating company. Again, this has to be a one-on-one because of privity of contract. So it has to be the student versus the company. But a few things here. So courts in general, they hesitate to interfere with freedom of contract. They don't want to do this because they don't want to essentially babysit people who enter into these agreements and that sort of thing. So if you have two individuals who have entered into a contract and the elements are there, as such that there's no, again, misrepresentation or anything like that. They're adults who have entered into the contract. The court is going to hesitate to interfere with that. They also aren't going to award damages resulting from a bad bargain. So what that means is if someone has essentially entered into the contract and they know what they were doing and they purchased the service, they received the service, and they felt that, I didn't get what I paid for, the court at the end of the day might say, well, this is what you paid for, this is what you purchased, and this is what you engaged in, and we're not going to award damages as a result of that. As Sarah had mentioned as well, we have jurisdictional issues as many of these companies operate overseas. And I also wanted to point out too, based on what students are paying as well, the cost of litigation, particularly in Canada, and the resources that are involved, we're probably not going to see a lot of this action because it's not a practical option for the average student. This isn't necessarily going to deter contract cheating operations as a whole, which is what our concern is here. We want to address contract cheating operations as we've seen other countries do. So that's an introduction as to why we feel that civil law isn't necessarily the best approach to address contract cheating. So now we move into criminal law, because this does seem to be, I think on the surface, a very natural area where we could potentially see contract cheating operations being sanctioned and deterred. So really quickly, just a brief introduction to our criminal law structure here in Canada. So criminal law is federal, as we would have noted under Section 91 of the Constitution, and offenses are codified in the criminal code. And essentially, what are these offenses? One of the classic cases there tells us that we're looking at actions or offenses that are abhorrent to the basic values of society. Another thing I wanted to point out too is that under our system, there's this presumption of innocence. And this ties with having to find the accused guilty beyond a reasonable doubt of committing both the act of the offense, so that's the actus reus, and then there's a mental element, which is the mens rea of the offense. So you need to have both of those elements according to how things were essentially written out in the criminal code in order to convict someone of a crime and find them guilty. So we do have a high threshold here in Canada. And this basically comes from this old English principle that we'd rather have, 9 guilty people go free than to have one innocent person be convicted of a crime that they weren't necessarily guilty of committing. So that's where that comes from. And I'm going to hand it over to Sarah now, because we did actually, well, she actually uncovered a very interesting case out of Toronto here.
And I found out about this. I have to give props to Jeffrey Berger, who wrote about this in his doctoral thesis out of Dalhousie University that he did around the turn of the millennium. He uncovered a case where there was an attempt to engage criminal offenses with a service operating out of Toronto called Custom Essay Service, provided the address of the service, and I was able to locate the current state of the building using Google Maps. So what you see on your screen there is a Google Map capture of where this would have been located in the premises in the mid to late 1980s. We don't know exactly which unit was occupied in the building, but we do know that this was the address. And there was effectively a sting operation that was organized by the Toronto Police Service in conjunction with members of York University who wanted to have prosecution brought against this custom essay service. And there was a raid that was done. They uncovered 530 documents, including student orders and other evidence that the company had provided outsourced academic work. And the proprietors were charged with multiple counts of conspiracy to utter forged documents and uttering forged documents. And before we flip to the next slide, I can also say we don't have it in our slide deck here, but it's also worthy of mention that there was an attempt to legislate against contract cheating in Canada in the early 1970s. The legislation attempt failed. Nevertheless, about 15 years later, there was this criminal case that was brought forward in Toronto against this one particular service. So then we can go on to the next slide. And based on what Alicia has told you so far, you're probably not surprised, though you may be disappointed to learn that the charges were ultimately dismissed due to lack of intent. So they were unable to prove criminal intent as a criminal act. And this was one of the things that Jeff Berger noted in his thesis. And some possibilities around this were including providing tutoring services, supplementary materials. We hear this in the marketing of these contract cheating companies, that they're not endorsing cheating in any way. They basically wash their hands of the element of academic misconduct. They say that they didn't intend for students to submit this for credit, which we know to be false by and large, and that they didn't actually create any false documents under the criminal code. So the judge didn't have the mechanism to prosecute under the existing criminal code at the time. But Alicia, you're the legal expert, so what would you like to add here?
I think you've got it, Sarah. And you know, thinking from the standpoint of if I was acting as defense counsel for custom essay service, like this is likely what I would argue. And I think the biggest thing that I would be arguing is that they didn't intend for the students to submit the materials for academic credit. You know, they were just providing students, again, with the supplementary materials. They can't control what students do with these materials after they're submitted, that kind of thing. So you can see how these companies operate and why it's a little bit more insidious and puts these students in a bad position. And you know, again, I'm not going to speak to sort of like from the student perspective, but if we go back to what we had seen in the Meeser case, that we're focusing on institutional integrity, maintaining that, looking at academic credentials and that sort of thing, this is something that we can come back to and say, okay, so if this is what we would like to see as institutions, you know, how can we sort of move forward and help address this issue? Another, this comes up as well. So individuals sort of saying, well, what about the fraud element? Because maybe there's an opportunity to look at fraud under the criminal code. And if you take a look at the fraud provision, which is section 380, again, speculative on our part, but what we feel is that it is a little bit more difficult to argue. You know, I think there's a question of, are contract cheating companies actually defrauding anyone based on how fraud is presented in the criminal code? So, you know, I think there is this question, again, going back to those previous defenses, that they're simply providing materials that students have ordered from them and have accessed and that sort of thing. There isn't necessarily that fraud element. Again, we sort of point to the fact that they're supplying students with legally purchased assistive material and that sort of thing. And we might actually, I actually think that, you know, fraud is probably more applicable to students who have purchased the materials and then are submitting it and saying that actually I created this, this is my own original work and that sort of thing. So again, we haven't seen any cases that involve fraud, but if you look at fraud within the criminal code and sort of dig into it a little bit and think about it from the perspective of a contract cheating company, I'm not too sure that that a fraud charge is a possibility based on the provision within the criminal code itself. And Sarah uncovered some very interesting information, so I'm going to hand it over to her to speak to this.
Yeah, this was through an examination of mainstream media reports of individuals who had been arrested in Canada during final exams on particular campuses. And students had hired an impersonator or contracted with an impersonator to write their exams as a proxy on their behalf. So we found 3 cases noted in the media. We've highlighted them here from 2014 to 2019. Of particular interest here is that no one university was targeted, that this was happening across different campuses. And I think it's no surprise to any of us that this has occasionally happened on Canadian campuses. But what we found is I had Alicia dig into the legal files after we gathered this information from publicly available mainstream media and say, okay, setting aside that sensationalism of what was reported in the media, what could you actually find in the court documents about these cases? And Alicia, what did you find?
Unfortunately, nothing. And the reason being is that like if a charge is laid, but this doesn't sort of realize the court and that sort of thing, there isn't going to be publicly available documentation on these charges, and then potentially convictions if it goes down that road. So we only see information about these cases move forward if the Crown essentially decides that they would like to take this to trial, they would like to pursue that charge and that sort of thing. So there haven't been any formal charges or convictions based on these arrests. So our best guess is that these people were arrested and that sort of thing, but they were eventually let go because there wasn't enough there to formally go through with the charge and see that through. So yeah, nothing to date, which is interesting, as Sarah noted. Is this yours, Sarah? I think it is, right?
We didn't have time to get into too much of the information around blackmail of students in today's presentation because we knew that we would be a little bit strapped for time with the content that we have, but we know that these companies will aggressively market to students and promise them things like model material, plagiarism-free material, high grades, and that the students will sometimes engage with these companies when they're experiencing high periods of stress and anxiety, and that after the student has engaged with the companies once, that they may be coerced through persistent texts and emails to continue engaging with the company. And so we know that there's a variety of behaviors that these companies engage in that are sort of just skirting the law. We know they might be immoral or illegal, and in some cases they might be outright criminal in terms of blackmailing students for more money. We know that this happens now. There have been documented cases. Earlier this year, the Better Business Bureau issued an alert regarding blackmail of homework help sites. So we know that this is happening to some extent. This was sort of beyond the scope of our presentation today, but we did want to acknowledge that these are sort of spin-off behaviors of some of these companies. And I'll hand it back to Alicia for further commentary on this one.
Yeah, and sorry, I jumped ahead there, but I will sort of close off the slide by talking about the fact that, as Sarah has mentioned, we do want to sanction this behavior, but it's difficult to do so given the existing structures. So as noted, like we do feel that there are hurdles associated with those civil suits, right? And I see a few of you have mentioned in the chat, and we'd be more than happy to address these questions and have some conversations at the end of the presentation. But there are issues associated with civil suits, especially if we're looking at from the contract standpoint, students engaging in these suits, like we said, lots of hurdles for them to overcome in order to be successful there. And then there are a lot of complexities associated with criminal charges. So again, finding the accused guilty beyond a reasonable doubt, on both the act and the mental element associated with the offense, there are some challenges. And I mean, this is not to say that we don't recognize the importance of criminal law and that sort of thing. We're not saying it should be easier or anything like that. We just don't think that this is potentially the best avenue to look at and address contract cheating operations as a whole. What we do want to propose, though, and what we think may be a possible solution to this, is looking at regulatory offenses. So regulatory offenses, they are criminal in nature, but they're generally related to provincial matters. That being said, federal parliament can enact regulatory offenses as well. So regulatory offenses or regulatory bodies that you may be familiar with. So we're looking at, the environment, things like that. And as you can see here, one of the classic cases here. So what they're meant to do is protect the public from potentially adverse effects of otherwise lawful activity. And we feel that this does relate to contract cheating operations because we have individuals who are engaging in, what may be perfectly lawful transactions. You're purchasing something and something that's being offered for sale and that sort of thing, but there is an adverse effect that we're seeing. And the adverse effect is happening to students as well as it's impacting post-secondary institutions. So there are three categories of regulatory offenses. So we have those that have the intent element. So those will be similar to your criminal charges where we're looking at proving the intent of the accused, the person who's accused of committing the offense. And then the second tier here, we have strict liability offenses. So this is where if you engage in conduct, there isn't necessarily that intent element that has to be proved. All we have to show is that you have engaged in the conduct, but your defense ends up being due diligence. So you may say that, I did everything that I could to avoid whatever the offense was. And that ends up being my defense, even though I did engage in the act itself. And then we have absolute liability where there isn't an opportunity to essentially defend yourself. It's if you're caught, this is happening. We don't go into it in this presentation, but within Canada under our legal structures, if there is an absolute liability offense, there can't be any jail time associated with this. So what that means is that absolute liability is essentially just looking at a fine or something like that. And they're essentially very rarely used anymore, is my understanding. What we're seeing is, again, these intent-related regulatory offenses or the strict liability offenses. And if we look at some of the laws throughout the world, this is what we're looking at here. I think I can go over to you, Sarah. Sorry, I don't have my notes because I'm in full screen. I apologize.
Oh, yeah, no problem at all. As part of our analysis and to prepare our report for Canada, we conducted an analysis of the existing and almost existing legislation in other countries, Australia, New Zealand, UK, and Ireland, along with 17 US states. Alicia conducted the legal analysis of each of those, and we will briefly take you through her overview to show you what she came up with. And she then compared what exists in other countries, both the US and other Commonwealth countries, to come up with her recommendations for how we might move forward in Canada. We'll say that a limitation of this work was that we only focused on countries where English was the primary language of instruction, because that's the language that we can work in to conduct our research, though wanted to acknowledge that other countries where English is not the primary language are also undertaking similar types of initiatives to look at what would legislation look like. And we can move to the next slide. And in conducting our review, it was curious to us the role that quality assurance agencies played, largely either behind the scenes or quite actively, and that basically legislation didn't happen in any of the Commonwealth countries without the active participation of the relevant quality assurance bodies in those jurisdictions. We feel that the role of quality assurance agencies is absolutely critical in this work, not only through proactive education in preventing contract cheating in terms of working with other government bodies and educational institutions, that institutions like TEXA in Australia and the QAA in the UK, QQI in Ireland, have really championed contract cheating and combating contract cheating, helping educational institutions with education, professional development, resources, and really the QA bodies have been the real champions of this, often being the bridge between the institutions and the lawmakers. And that was a key thing that we found as part of our analysis of this material. And that in some jurisdictions that they played a critical role in ensuring that legislation went forward. And some of the quality assurance agencies might be responsible for investigating and bringing charges according to those contract cheating laws. And we're not suggesting that's a role that QA bodies in Canada would or should play, but merely noting that this is a function that is played in other countries. And so I think in the slides that follow, we'll show you Alicia's high-level legal analysis of existing legislation, and then how that led to the recommendations that we present before you today. So we'll start with the existing contract cheating laws in the United States, and I'll hand things back to Alicia for her overview.
Yeah, and we do want to acknowledge some work that had been done by some academic integrity scholars who sort of did this work initially looking at some of the US states. But essentially what we found when we dug into the laws was that the majority of states that have laws that relate to contract cheating, so they have made an offense to offer, advertise contract cheating, all of the states you see listed here, so 16 of them in total, these offenses require intent. And the penalties will range from anywhere from fines to a little bit of jail time if you are convicted. So the majority of US states do require intent associated with the offense of engaging in or offering contract cheating services to students. The only state that doesn't utilize the intent required offense is North Carolina. So theirs is a strict liability offense, where if you are caught offering or advertising contract cheating services, that essentially means that we don't need to prove the intent there. You can try to argue due diligence, but essentially, yes, if you've offered it, that's what they're looking at. And as noted, we are looking at the companies themselves, so offering and advertising contract cheating services. Some of the laws also target people who purchase and submit materials for academic credit. So that may be, we didn't take a look at some of the policies of institutions located within these states, but it is interesting to note that some of the laws in the states do also encompass those students or individuals who are purchasing and submitting those materials. And I did mention the penalties before as well. When we look at these laws as well, I did want to point out that a number of them actually in their legislation differentiate between contract cheating and tutoring services. So an example here is California's Education Code. Sorry, this is an example of the intent, but going back to the tutoring services, they do talk about how if a student is engaging in essentially a legitimate tutoring practice, that's not considered to be contract cheating. So they are careful about specifically honing in on the essay mills, the companies that offer essentially, material that can be paid for. And an example actually of the intent element here I wanted to point out. So this is California's Education Code. So they talk about targeting persons offering contract cheating services where it should be reasonably known that the material would be submitted by another person for academic credit. So again, it doesn't have to be proving the contract cheating providers, state of mind, did they exactly know this? It's essentially just saying, like, if you reasonably knew that students were going to submit this material as their own, then that's going to meet that intent element for some of these offenses. And in general, that's what we're looking at with the requirement for intent in a lot of these laws. So it's not too onerous, but as you can probably think of ways that a contract cheating company could potentially circumvent this intent element, right? Especially if they're very careful as to how they present information on their websites and that sort of thing when they are advertising their services. And if we move to our fellow Commonwealth countries and what they have done, as Sarah noted, these countries all have quality assurance boards, and they were very heavily involved in enacting legislation, and they are still involved in essentially prosecuting and moving these charges forward. So in Australia, we're looking at strict liability, but intent is required for one provision there. all of this is located in our report. So we can go into the detail, I would say, in the report itself, because I don't want to get into the habit of reading out the provisions and that sort of thing for the purpose of the webinar. In Ireland, they also use a strict liability model. New Zealand is an offense requiring intent. So similar to the ones that we'll see, the one that we just mentioned in California and some of the other United States there. And then in the United Kingdom, this legislation is forthcoming. They are looking at enacting a strict liability offense. So what we see again is a focus on the companies themselves. So offering to provide or advertising academic cheating services is considered to be an offense. The penalties are very similar. So they range from fines to imprisonment. And here we see that legislation was enacted to address the increase of students accessing contract cheating services. And I'll hand this over to you, Sarah, just to speak about this in detail, because I know this is something that you've engaged in with your research.
Previous to this year, many of us relied on a meta-analysis that was conducted by Guy Curtis and Joe Clare that was published in 2017 of existing research on contract cheating, largely focused on self-reported data. And from that meta-analysis, they came up with about an average of 3.5% of students, though with variations among particular student groups and even in particular countries or academic disciplines. So in other words, prior to the pandemic, we had sort of a best case guess based on a meta-analysis based on self-report data. More recently, Guy Clare and colleagues in Australia used a new method where they collected empirical data directly from students about contract cheating behaviors. They collected their data during the pandemic. And they came up with a new revised estimate and then claiming themselves that their old report, relying on self-reported data from students, was perhaps not the best or most accurate way to get an understanding of how many students are engaging in this behavior. In their most recent research that was published, I think it was just last month, they've now come up with a new number of about 7.9% of Australian students who utilized commercial ghostwriting services or commercial contract cheating services. So that number's gone up quite a bit from 3.5% to 7.9%. Impossible to say if it's only a result of data being collected during the pandemic or a new method for them of collecting data using what they called enhanced truth-telling approaches. Guy Curtis is a psychologist, so was using some techniques that they use in psychology to elicit truthful responses from research participants. But what this does is signal to us that perhaps our overall understanding of the rates and prevalence of academic contract cheating were underestimated prior to this. Some limitations of this research is that it was only conducted in Australia, so we can't necessarily extrapolate to Canada or other jurisdictions. It certainly signals the need for us of increased research to better understand what's actually going on in our own countries, because certainly in Canada, we don't have a great sense of that right now of what's going on. But the work that they've conducted is pointing to increases during the pandemic as well. Again, it's imperfect in that we can't apply it directly to Canada, but certainly signals to us that we need to be paying more attention to this problem. And we can see some new developments that have happened in just this month alone in October. So as Alicia mentioned, in the UK, contract cheating legislation, I think, Alicia, it's just gone past its third reading in the legislature, right?
Yes. So it's very close to being enacted. Yes.
Mm-hmm. So this was exciting because I know the colleagues there have been working on this for quite some time, again, with the support of the QAA over there, that it looks like they will be getting their legislation finalized before the end of the year. And also of note, I'll hand this over to Alicia in just a second. And this was kind of a sensationalist headline in Times Higher Education, that first blood for Australian contract cheating law. They've actually implemented the law. So it's one thing to have a law on the books, but it's another thing to actually implement it. And Alicia's dug into the results of what's been happening in Australia just this month. So did you want to tell folks what's happened over there and what can we learn from how Australia's implemented their law?
Yeah, so this was certainly an interesting decision to read. And as Sarah noted, essentially the first of its kind that we've seen, not just in Australia, but I would say even worldwide. So as noted, Australia, through the assistance of Texas, so that is their that's their quality assurance agency, enacted the laws that sanction contract cheating. So they were looking at offering, advertising, and providing contract cheating services. So under the legislation there, the Quality Assurance Board, so TAXA, had found a website that was offering contract cheating services. And they sought an injunction from Australia's High Court to essentially block the DNS of the website. So what that means is essentially they worked with, they're called carriage providers in Australia, but essentially internet service providers, to block access to this website. So that's of interest because this is a way that Australia thought to get around jurisdictional issues, essentially, right? Because we're dealing with companies that aren't necessarily operating in the countries that they are essentially targeting the students from. So this particular company ran out of India and they were targeting students in Australia. And this was found to be the case because on the website, they actually mentioned a number of the tertiary institutions in Australia. So Melbourne, Western Australia, and that sort of thing, like these institutions were specifically mentioned on the website. So that was a way for, I think that was a creative way that Australia thought that they could work around the jurisdictional issues. So they thought, we know we can't, essentially tell you to shut down or cease your operations because you're in a completely different jurisdiction and that sort of thing. But something that we can do is we can work with the internet service providers in Australia to block access to this website. So is it necessarily a perfect solution? I think as time goes on, we will see whether or not this works because, as Sarah had noted before, we're dealing with some savvy companies that are probably thinking of ways to get around the laws. So this decision is interesting because they initially targeted a website. It was assignmenthelpforyou.com, and essentially the solicitor with the Australian government had contacted the website and said, according to these laws, you need to stop advertising your services within Australia and that sort of thing. And if you don't follow these instructions, then we are going to be taking action and we'll be bringing this to court. And then what happened shortly thereafter was they sent a second warning to the website. And then all of a sudden, the website assignmenthelpforyou.com went down and it appeared to be for sale. So TAXA did some investigating and they found essentially what was an identical website on a different domain. I think it was like assignmenthelp2u.com or something like that. So what they did was they moved their website over to a different domain. And there was some speculation as to whether or not the contract cheating company intended on moving back to their original domain after the assignmenthelp2u.com would have been essentially blocked. The DNS blocking would have occurred for that website, and then they would have moved back to their original website. So the court held that, no, this isn't going to happen. We are going to block all of those websites. So they did agree with Texas that the websites should be blocked, and they ordered the carriage service providers to block access to these companies. So an interesting approach. It was exciting to see the first case actually go through. So what they had wanted to do was set some precedent within Australian law so that they could move forward with these kinds of charges and decisions and that sort of thing. But I think time will tell to see how companies will react and how this will impact contract cheating operations within Australia and also worldwide. So we certainly have our eyes on Australia and things that are happening down in Australia, because we do feel that they have sort of come forward with a very model approach. So when we move forward, what do we recommend? I'll take this first one here, Sarah. So how would this work in Alberta? So I did a little bit of digging into some other existing legislation, and this is mentioned in our report, but Alberta does have a Consumer Protection Act. So what this act does is it provides Albertans with an opportunity to essentially signal to the government through their Director of Consumer Protection that a company has, they have unscrupulous practices and that sort of thing. So the act itself mentions like payday loan companies. So companies like that, they can essentially signal to the government that this is happening, and then the government can choose in the public interest to act against the company itself in order to protect consumers. so that is a mechanism, and we thought that that could be a possibility. But again, the challenge is jurisdictional issues arise. There are a number of contract cheating companies and that kind of thing. There's also this element of essentially convincing the director of consumer protection to take some action, because this is in the public interest. So we do feel that it is in the public interest, because again, we're looking at maintaining that institutional integrity. We're looking at ensuring that the credentials that are awarded by academic institutions are fairly earned by students. And this is something that we see in legislation, not only in the United States, but it's heavily emphasized in the Commonwealth countries. So Australia's Act that includes the contract cheating sanction provisions actually does mention that. So the reason why they're doing this is because they want to ensure that individuals who are going through their institutions are fairly earning their credits and taking their courses and that kind of thing. So it is in the public interest, because you want to have confidence in the fact that individuals who are graduating from these institutions have fairly earned their academic credit. So instead of essentially targeting the students, they're just wanting to nip this in the bud, go directly for the contract cheating companies. So Consumer Protection Act does provide a possibility, but again, it isn't a perfect solution. So this is where we come in with our recommendations, and I'm going to pass things over to Sarah to speak to this.
Yeah, and I should probably just highlight, in case it wasn't obvious in some of our earlier slides, that all of the existing legislation goes after the companies and the suppliers of the cheating services. So to the best of our knowledge, the existing legislation doesn't go after the students. That is covered under institutional policy and procedure. And certainly in the case of Custom SA Service that we saw in Toronto in 1989, the police didn't go after the students at all. They did provide their partner in the matter, York University, with copies of the materials that they retrieved that pertain to students at York Universities, and some of those students faced harsh penalties and sanctions. So when we talk about legislation, we're not talking about going after individual students. What we want to do is curb the supply side of the industry rather than the demand side. And the demand side is addressed through institutional policy and procedure. So in our report, we came up with sort of 5 broad recommendations. The first one was for institutional policies. We know from some of our own research that by and large, institutions don't track incidents of contract cheating. It gets subsumed under collusion, plagiarism, unauthorized assistance, or other forms of misconduct. In order for us to better understand what we're dealing with in Canada, one of the key steps that institutions can take in their own policies is to actually name contract cheating, and in particular, commercial contract cheating, contracting with a third-party commercial provider, so that you can begin to track incidents of this and understand the actual prevalence on your campus. If it's only couched under other classifications, and if it gets mixed up with plagiarism or something else, you may not know what's actually happening in your own school. So that was a key recommendation for institutions right there. And then if your institution does produce an annual report around academic misconduct, most of the publicly funded universities do. I assume that some of the colleges do as well, to name this and bring it up on our campus. This shouldn't be a taboo topic to talk about. One of the things I've observed anecdotally in my own research is that individual institutions can get very nervous talking about this, thinking that it may damage their institutional reputation. So there's safety in numbers. And as more institutions start to bring this to light and we can discuss this in open and broad terms, then no one institution is at risk. And we're dealing with this as a higher education sector rather than as individual actors. Nevertheless, we still need data and information at the local level. We've seen in some of the work that we've done, I think it was the UK, Alicia, you can correct me if I'm wrong. We saw the provost take an active role in some of this at the universities. The provost worked with the quality assurance bodies, and they petitioned the government for legislation to enact in the UK. That's how it went there, right, Alicia? Yes, I see you nodding.
Yes,
So we
yes.
see this this partnership model between the senior executive level university and college leaders, the presidents and the provosts, working hand in hand with the quality assurance bodies and other in the UK national level bodies, and they in turn work with and influence the politicians to enact the legislation. It's not like one day we just wake up and suddenly we can have legislation. This takes a few years of preparation, and certainly in our informal interviews with leaders around the world, our colleagues in Ireland let us know that their process took them 7 years, from the initial idea and starting to plan it to actually getting their legislation implemented there. So if we were to start today, it would be reasonable to assume that this would be a 3 to 7 year endeavor for us to think about legislation. But now is the time to do this. And we need to have the input and active participation of our executive level leaders at every institution engaged in this. I've said this before, I'll say it again, and I say it in our report that I'll share with you in the chat in just a moment, that this needs to be on the agenda of Universities Canada, the college equivalent, as well as CMEC. Until and unless we get the national level bodies talking about this, I don't believe that we'll get action across Canada. And to help us, we need to be able to provide an evidence base. So in Australia, for example, where they have legislation, they also had well-funded research programs of key individuals across the country who not only worked on contract cheating research themselves, but they collaborated with colleagues across their country, across the various states there. So they were looking at multi-institutional, multi-state research that led to empirical data being collected from thousands of students, and they call them staff, we would call them faculty, in Australia. So they had a really strong empirical research base from which they could then leverage and say, well, look, we've got the data, we've got the results. So legislation flowed out of that. That research was funded by their national research funding bodies. We have very little research funding in Canada to do this work, and certainly not to work across provinces or across jurisdictions. This will be crucial for us if we want to provide empirical evidence to make our case that legislation is worth the time and effort it would take to make it happen. And in terms of our quality assurance bodies, have been connecting with some of our quality assurance professionals in Canada, and to make academic integrity an even more important priority as part of program approval and renewal, etc. And this is what we've seen in other countries, and as well as QA bodies providing resources, information, education, webinars, etc. In Canada, we often rely on resources produced in other countries, the QAA, TEXA, and most recently Ireland has 2 new documents that they just launched last month. At the federal or national or even provincial level, we don't have a lot in Canada in terms of resources. And I think this is an opportunity for us to partner with our various QA bodies in really productive ways that can help to strengthen these partnerships and also bridge gaps between academic researchers, policymakers, administrators, educational leaders, and others who work in the academic integrity sector, so that we are working together and in unison on this, and that we don't have such a fragmented approach. Once we start to work together more collaboratively across sectors, we'll be able to tackle this in a much better way. And so I'll conclude with the recommendation for legislation, which is why I know so many of you are here today. So Alicia, if you could recap in 1 or 2 sentences, imagine we have a policymaker here with you today and says, okay, Alicia, in your capacity as a legal expert, what is your recommendation for contract cheating in Canada?
Yeah, thank you, Sarah. And I hesitate to use the term legal expert as well, because I also, as Sarah noted, like, I think a lot more research needs to be done, and we really scratched the surface of this. So super excited to see what can be done and what's uncovered in the future. But essentially what we're looking at, and I did notice this mentioned in the chat quite a bit. So what we want to do with this legislation is essentially target the companies. So there are mechanisms in place that address contract cheating, plagiarism, essentially like academic misconduct. So there are mechanisms in place to address students who engage in this kind of behavior, but there aren't the mechanisms in place to essentially, like we said before, go to the root of the problem. So, stop providers from offering these services. Now, is it going to be, you know, a complete sanction? You know, we're not going to see these companies operate anymore. Of course not. However, we do feel that this is deterrence, essentially, that we're looking at here. So what we would like to see is legislation that addresses contract cheating operations. So similar to what we've seen in our fellow Commonwealth countries, as well as the United States, is looking at companies that offer, provide, and advertise contract cheating services, and looking at enacting that regulatory legislation that would make that an offense. And we do recommend, for the sake of simplicity, something more along the lines of the strict liability offense, because there isn't going to be that intent element associated with it that you need to prove. And that was a recommendation that actually came out of Ireland. Our Irish colleagues were the ones who noted that as well, and that's what they had lobbied for in Ireland itself. So we also recognize too, you know, like institutions can't enact legislation. This is something that the government has to do. That our policymakers have to do for us. So that's what Sarah was mentioning before, that we are looking at working with people who are influential and can help us work with this, and look at enacting legislation that's similar to what we've seen, particularly, I will say, in the Commonwealth countries, because we were really excited to see that decision come out of Australia, and we're also excited to see what comes out in the future. So anything you want to add, Sarah? Anything that I've missed?
No, I think we can move on to the conclusions. And just to highlight for you, if you haven't been monitoring the chat, as your key takeaway from attending today, we have dropped a copy of our full report into the chat. We've also sent it to our library for permanent archiving in our digital archives, and that will be available shortly. I will email that link out to everyone after the webinar, but I wanted you to leave, because we've talked about our report throughout. So I wanted you to leave with that so you can take it away and read it in detail. So in closing, we know that legislation is not going to solve the problem of contract cheating. So often we know that people look for a silver bullet or a single solution, and there's no single solution to this complex problem. This is one of the wicked problems that exists in education, particularly higher education, though we know it also impacts K-12. We know that it won't solve the problem, but it can be part of a suite of responses to help address this problem. And we know that individuals are basically powerless to take action against these companies by themselves. We know that institutions are hesitant to talk about this for fear of it damaging their institutional reputation. But we know that when we have multiple ways of addressing this at various levels, from individual educators have resources and are empowered to report it, to having policies in place in institutions to address it within the institution, to having legislation enacted that can help to combat contract cheating from external to the university, and with the support of the legislative bodies, that is the way that we believe that we'll be able to address this. And as we review the legislation that's either available or forthcoming from other countries, it became obvious to us that given the number of countries that have or will be enacting legislation against contract cheating, that Canada is now falling behind other countries. And as it becomes more difficult for contract cheating companies to operate in those jurisdictions, they will no doubt look for more fertile grounds to operate their business. Canada is becoming increasingly vulnerable as it becomes more problematic for companies to operate in other countries. For this reason, I think we need to consider legislation so that we're joining our Commonwealth cousins as well as the United States in taking a global stance against contract cheating. I would also like to give a shout out here. I know we have folks here from the International Center for Academic Integrity, and they've done a significant amount of research that helped to inform our study, and also lead the International Day of Action Against Contract Cheating every year, and have done so for several years. And so these international agencies are also crucial in helping to advance this conversation. So we're calling on all bodies at all levels within institutions, within quality assurance, legislation, and also nonprofit organizations around the globe to keep going with this work, because collectively we are more powerful than we are individually. So we'll close there and take your questions and comments at this time. We have our webinar production coordinator here, Helen, who's been monitoring the chat for us, and we can certainly take your questions.
Thank you so much, Sarah and Alicia, for that fantastic presentation. You covered so much in the time that you had, and I'm really glad that we have about 20 minutes or so to cover some of the questions that have been asked in the chat so far. So I also noticed that some of the questions that were asked earlier on ended up getting answered either in the chat or throughout your presentation. So just want to acknowledge that we'll try to make time for as many questions as we can. I know you had so many curiosities about the legal side, the ethical and moral side of contract cheating. So we'll try to get to some of the major points that were discussed in the questions in the chat. And maybe I could start off with a question about how difficult it can be to litigate with some of these contract cheating things. So I'm curious about asking this one question that was from the chat. Is there any way to litigate based on the platform contract cheating site holding materials that might violate intellectual property laws or copyright laws that might be housed within, for example, a higher education institution?
I think this is an excellent question, and I'll hand it over to Alicia in just a moment, but I did want to state, of course, that neither of us is an expert in copyright law, and so we may not be able to adequately address the question, but I think it provides a basis for some really interesting discussion and intersections with other kinds of laws that we haven't discussed. So we've sort of addressed this in terms of basic supply and demand, but we are noting the overlap with other kinds of laws, such as intellectual property and copyright, that went beyond the scope of our report that we did together, but it does provide an interesting basis, as I said, for further discussion. And we're certainly seeing on commercial file sharing sites and other sites where companies are appropriating materials for which others hold the copyright. Whether it's an individual who's created the materials or an institution that's created the materials. And then in some cases, we see the contract cheating companies or commercial file sharing companies rebranding them, saying copyright with our company name on them, when they in fact were not the original copyright holder themselves. So we're starting to see those kinds of breaches. My sense as a non-legal expert is that that would be a particularly difficult thing to try and pursue from a legal perspective. And I'm not sure what the possible outcomes would be that one could go through, especially if the different parties were in different jurisdictions. And I know Alicia is a law student, so I don't want to entirely put her on the spot to comment from a legal expertise point of view. But I did want to just open the floor in case you had any additional thoughts based on your training.
Yeah, thanks, Sarah. And this is an area I actually haven't delved into. So unfortunately, not something that I can address, but I echo Sarah's comments that a very interesting question and area that I think is ripe for a lot of research and inquiry because yeah, I think that, I mean, in general, I think questions of sort of intellectual property as they relate to academic assignments and whatnot is an interesting one. So my apologies for not being able to provide more information, but I do want to acknowledge that that's a very good question.
Yes, the area is so complex and the law is so complex, and we mix in the regulations that institutions individually have. So it's definitely clear to me how far reaching this issue definitely is. So we had another question early on that I thought was interesting about where the line might be between editing services such as Grammarly, which provides grammar advice as like technology provided grammar advice, versus human editors that might be reviewing or writing papers. So Grammarly and these companies might also have another additional layer of complexity where they might hold ownership, right, once a thesis or other academic paper might be uploaded. So I was wondering if you could comment a little bit about the complexity of the services that some of these different companies and technologies might be offering.
Yeah, this is a fascinating question. And some of you are on the call today because you're part of our regular integrity hour, our online community of practice where we talk about academic integrity once a week, every week, Monday mornings, Alberta time at 10 a.m. And if you're interested in learning more about our community of practice, then you can reach out to me. My email address is on the screen. We actually tackled this very topic recently in one of our integrity hours, and really we didn't come up with any clear answer around it. I did want to provide a resource that I think actually Canada is doing an amazing job at, and that we have a professional association of editors in Canada that, like other professions, editors can belong to this, and they can both use it for networking and business development, but also for guiding principles. And the Editors Association of Canada has come up with their ethical guidelines for editing of student texts. And it basically provides their members with guidance on what to do as an editor and how not to cross the line into misconduct. And to the best of my knowledge, there's no similar guidance provided for editors in other countries. So I've actually referred this resource to folks elsewhere to say, if you're looking to understand that line, because I think it can be a gray line in terms of where does help turn into misconduct, not only for editing, but for other kinds of help and tutoring as well, right? And this is sort of one of those complexities around this. But I think things like this, where a professional association has laid it out for their members and said, look, we expect you to conduct yourselves in an ethical way. We know that there can be some gray area, and here's how to deal with that. So this, I think, can help institutions as well provide guidance to their students. And what can they ask an editor to do or not do? I know when I was a graduate student at the University of Calgary, it was forbidden for us to work with editors, and that has changed over time, and that now students can work with editors, providing that they're not helping students cheat or writing the work on their behalf. So again, not cut and dry. I mean, if there's one thing I've learned from working with Alicia and others in this space is what we have in those nice little neat packages in our policies and procedures are very rarely so nice and neat in actual practice. Being able to think through some of the nuance is particularly helpful. And with respect to some of the online services that you've mentioned, I like to refrain from referring to particular companies in any of my presentations, but I will share a quip that one of our former I think it was our chief information officer, chief technology officer at the University of Calgary once shared with me. And it was advice that if you're not paying for the product, certainly in terms of technology, then you are the product. And what they meant by that was, if we're not paying for these products online, if they're so-called free services, we need to ask ourselves, what is the company getting out of it? Because the company's purpose is to make profit. That's what they're there for. That's why business exists. So if we're not paying them, what are they getting? Often they're getting data, and that data can come in the form of personal information, other forms of data. But if students are uploading their work and their intellectual property to an unknown third party for help, what's happening to their academic work? And I think it's a question that students don't often ask when they're going online to ask for free assistance from companies. So it's probably sort of a big discussion that we can't get into today, but I always like to advise students to just be wary in terms of digital citizenship, of when and how they're surrendering their own intellectual property, and just ask themselves, if it's a commercial entity, what's the company getting out of it? It's a question I think that so many of us can't answer yet. Alicia, I don't know if you have anything you want to add in addition.
Not necessarily, but like I do want to point out that a lot of the legislation we looked at does, and I did mention this in the presentation, like it does specifically mention that, you know, tutoring services aren't covered by the sanctions that are listed there. So I think that you know, though the countries that have enacted legislation have been careful to say that, so, and differentiate between what we think of as like contract cheating operations, like the essay mills and that sort of thing, with someone who offers, you know, one-on-one tutoring services and that kind of thing. So I don't think these laws are meant to limit, and I'm going on a tangent here, sorry, but I don't think those laws are meant to limit sort of that one-on-one tutoring and that sort of thing. Like it's meant to deter like the larger operations that, as we've noted, do have a tendency to take advantage of students who may be in more vulnerable situations.
And building on what you were just mentioning there about the sensitivity of this legislation to legitimate services that are there to help and support students, compared to services that we would deem as providing contract cheating services, right? So someone was asking about, it can get tricky. It can be tricky to determine criminal intent when a contract cheating company, someone who's providing that service, is advertising tutoring. And what they're saying is maybe different from what the legislation might be referring to as contract cheating. So I'm curious if you could just comment a little bit about how that wording or that framing might work with the legislation.
I can jump in here and start. And it's interesting for me. I recently attended the Australia Academic Integrity Network conference that was held, I think it was last week. October's been a blur. But there they were commenting that the sort of traditional or clear-cut forms of contract cheating, such as a student going and buying an essay or assignment from a supplier, is shifting, in their opinion, that they're seeing a lot more of what they're considering shady services. So offers of tutoring for students. Tutoring sounds like it's help, it's benevolent, it's supportive, when really what they're doing is hiring someone to complete the academic work on their behalf. And I think from having listened to our colleagues there, because we're often turning to colleagues there for leading the way around contract cheating, they're looking at also increased efforts for consumer advocacy for students, so that students know what they're getting into when they're engaging with a tutor or an editor. There are legitimate student supports to help students succeed, and in no way do we want to imply that students shouldn't ask for help where it's needed. I think a really great resource for students in so many of our schools is to go to their student success center or their student affairs office and say, look, I need some help with this. Is there a good place that I could go to? Or if those student affairs offices won't recommend particular companies, they might be able to flag for students some things that they should watch out for in terms of buyer beware for those students, so they can learn to protect themselves and not just be so trusting of other third parties on the internet or other companies that are reaching out to them. I'll often advise students, I'm like, if a company is reaching out to you, offering to provide you with tutoring services or editing services, you probably don't need them. They need you. And that if students want to engage with an ethical tutor or an ethical editor, that there are ways for them to do that. And still, largely the onus is on them to find a reputable person to work with. And I did want to share one additional resource that I'll just pop into the chat. And it was led by someone at Norquest College, Dustin Grew, but talked about the parallels between the contract cheating industry and organized crime. And it was a fascinating perspective for me, because he looked into the ways in which contract cheating companies are effectively laundering their services through allegedly legitimate activities, such as tutoring, but using it as a front for the illicit business, or the even, it's illicit, it's not illegal in Canada, the illicit business of dealing in contract cheating services, which is actually the moneymaker. So it was a really interesting set of parallels. So I'll leave that there in the chat for you as an additional takeaway resource for you to have a look at. We touched on that only very briefly in our report, but I do think it's worth investigating, as our Australian colleagues are starting to point out that these companies are getting very creative in the ways in which they are developing new lines of business to ensure that they continue generating revenue. Alicia, any further thoughts?
Yeah, I think just speaking to like how legislation should be worded. So not being a drafter myself, I would definitely leave that to the experts. But what I would recommend is taking a look at some of the existing legislation. So, we keep highlighting Australia. I think Australia's legislation is actually pretty well written. Like, I do appreciate like the definitions that they've provided for sort of contract cheating, tutoring, and that sort of thing that can help guide any charges that are brought. And the decision itself that recently came out, the judge also goes over, defining what it means to be a provider, and providing some other definitions as well. So I would say take a look at those for some interesting like resources, and also just further insights as well. And I'll say too, like I know, like Sarah really emphasized like the role that the quality assurance bodies play. And I think that having those quality assurance bodies, so you have this body of experts. So these are people who like their area of expertise is to essentially, you know, ensure the quality of education. And this goes all the way down to K to 12 up through higher education. Like their role and their expertise helps them to conduct some of the research that they need to do. So looking into a potential company and then asking the court for that injunction. So what I would say is them having that expertise, I think, is also useful as well, because I think they, based on their knowledge and just them, again, being experts in the field, are able to tease out, you know, this is a legitimate resource for students. This one, not so much. I think what we're seeing, as Sarah noted earlier, is a company that is sort of, you know, hiding behind the sheep's clothing and acting a little bit more insidiously to offer what is ultimately like contract cheating, you know, SA mill style services. So yeah, I would say like as a starting point, like some of the existing legislation is really interesting to read. And I would say Australia for sure, Ireland, like in particular, some of our Commonwealth partners there.
Now, I have one question that maybe will be our last question, or maybe I'll have an opportunity for both of you to comment on if there's anything you'd like to say in closing, just knowing that we couldn't get to all of the questions that were in the chat. So you mentioned some of these exemplars of Commonwealth countries, especially who have some of this legislation in place, especially Australia and Ireland, as you were just speaking about, Alicia. And maybe it's too early to tell for this, but I think we had a really interesting question from someone where it was asked, have you found in countries or states where there are sanctions, and I think they're meaning legal sanctions and legislation against contract cheating, that there's been an impact in students curbing contract cheating behavior? Has this had an impact on students? Has it had an impact on the industry of contract cheating?
I can speak to this briefly. I always caution against looking for cause and effect relationships in this kind of work, even in the work that I do. You know, we always say, well, if we do this, then will that be the result? And I think the question that we need to ask is, you know, to be able to understand what are the conditions that students are learning in now, including these external, I'll just say it, they're predatory companies for these students, and how do we help them learn? This is a question that was posed by, you know, Dr. Tricia Bertram-Gallant in one of her key pieces of scholarship in 2008. And she challenged us to reframe the question from why are students cheating to why aren't students learning? And even though that, you know, she wrote that more than a decade ago, that question just continues to resonate with me in such important ways. Students come to our institutions to earn a credential, and to earn a credential from reputable institutions and to learn. So if our students aren't learning, then we're not doing our jobs. And so I tend to push back a little bit on cause and effect kind of things, because I'm not sure it's that simple of an equation. But I do think that one of the things that we want to do in our efforts to combat contract cheating is to diminish adversarial and antagonistic relationships between students and their professors, or between students and their institutions, and instead create a narrative that students are here to learn and we're here to help them, and that we each play a role and responsibility in taking proactive approaches to ethical teaching and learning that includes academic integrity, ethical assessment, and standing as role models for a student. That doesn't mean that we get up in the morning and polish our halos and then we all are learning as we go, but that we're here to support students, and they're the reason that our universities even have their doors open in the first place. So I don't know of, to answer the question in a straightforward way, I don't actually know of any research that looks for that cause and effect between legislation and decreases in misconduct. I think in some ways the legislation is also quite young, apart from what's been done in the US that was done in the 1970s. The other countries have enacted legislation just in the past few years. And we know the reporting lags behind even tracking. So I think it might be too early to tell. So to answer your question, I don't know of any such studies, but I hope that that commentary provides some rationale as to why those kinds of studies might not exist.
Agreed. I don't really have anything to add, but I echo Sarah's comments.
Well, we're at 11:23 Mountain Time here, which means we have a few moments left in our webinar time today. And I would just like to pass it over to both of you, Sarah and Alicia, if there's anything that you would like to say in closing, anything that came out to you in the chat comments that you'd like to comment on, and just share some closing words to finish us off today.
Go ahead, Alicia.
Yeah, I guess in closing, like this was a really interesting thing to look at. So thank you all for being here today. Again, as Sarah noted, like we know this is a very complex issue. Like we're really just scratching the surface of this. And, you know, we do recognize that if anything is to happen, we're looking at sort of like long-term impact down the road. So, so yeah, really, this was like an exploratory exercise that we've engaged in, and we really appreciate you being here. And because it is like it's exploratory and it's new, we really appreciate those thoughts and comments, because I think this can help inform like future direction that is taken and how we move forward. So yeah, I would say thank you for being here today, and that's it for me. Over to you, Sarah.
Yeah, thanks so much. And I'll close with a reflection, and that, you know, our university president, Dr. Ed McCauley, talks a lot about transdisciplinary research, and that being research that cannot be conducted by any one person alone, because the issue or problem is so complex that it spans various disciplines and necessitates the collaboration of scholars and others across various fields of study. And I think a project like this is actually a great example of a non-STEM field, transdisciplinary issue or problem. I could not have done this work on my own. I lack the legal background and expertise to be able to conduct the kind of analysis that Alicia has undertaken in the preparation of our report and our slides. And so I think it's a signal to us of the ways in which we have opportunities to work together across fields of study, disciplines, universities, provinces, and otherwise. And if you are interested in connecting with us, please reach out to both of us. And I know that there's lots of people here today from our academic integrity community. And I'm just so grateful to have the opportunity to work with everyone in this community across Canada and beyond. And hopefully we will be able to see some movement on this in Canada in the coming years. So stay tuned.